Yes.
Yes. Your Honor, my Lord, item number 3. I would
Your
like
honor
to,
is also not bad.
yeah, I would like to withdraw.
Oh. Item number?
3. There's some amendments there because I have not made a party to victims.
You have not made the party.
Yes, so I would like to withdraw.
Your name? Your name?
T. Dukom.
T. Locum Learned Counsel for the petition on instruction submits that he be permitted to withdraw the present bail application with liberty to refile the same, if so necessitated. Full stop. Prayer is not objected to by the learned additional PP appearing for the state respondents. Full stop. Accordingly, the bail application stands dismissed on withdrawal with liberty as spread for.
And item number 1-3. 1-3. I'm appearing on behalf of C. Mantu. So he's some medical problem. He could not turn up. So I have already taken consent from the government. Item number 1-3.
Okay.
Entry may be continue. And
I was there in the division.
Yes.
List this matter before any other bench without me. Mera naam likh. John, the interim order.
Maybe continue.
How can I? If I can't take it up, I should not. You make a mention. Don't object at that. Then, next.
Mayor, my lordship. My lordship, I beg to mention item number 9. This matter will be listed after a week.
You have not filed your affidavit.
Yes, my lordship.
You have informed the other side.
Yes.
On the prayer made on behalf of the Learned State Council, Government Advocate, Arunachal Pradesh, appearing for the state respondents for an adjournment in the matter, same not being objected to by the Learned Council for the petitioner, registry to list these matters again after.
I'm agreeing for the petitioner in this matter. Can this matter will be short
2 weeks. After 2 weeks.
Be listed on next week.
She has to file her affidavit. We are giving her last opportunity. Before the next date of listing, the state respondent shall invariably bring on record their stand by way of filing an affidavit. In the event the affidavit is not so filed, this court would proceed to consider the issues arising in the present petition basing on the materials already available. 3 weeks. 3 weeks.
May I, Your Lordship? Lordship, I beg to mention item number 15 and 16. This matter to be listed on this 29th, Your Lordship, on behalf of Arish Nabam AAG.
Madam, what happened to the recruitment process?
Actually, yeah, I'm not appearing, Arish Nabam, Your Lordship, is not present today.
Because he was given that work. Then subsequently you went for a direct recruitment, you have recruited people. What happened to that process? What happened to that process?
Actually, this court is already interior model outcome of the petition. But that other recruitment has very high risk on filing a petition advertisement report without any closing of tenders. The direct recruitment.
Oh, it's up to them. How can we prevent them? If they want to make a direct recruitment, the people under their control, fine, it's for them. They don't want a contractor, they want a direct employment. Fine. How can we question that? You are paying for, madam?
I'm for respondent 4, Your Lordship.
No, who is the counsel?
Oh, yes, AAG Arish Nabam.
Yeah, Nabam. A prayer is made on behalf of Mr. R.H.
This is several times the adjournment.
Okay, we'll consider it today only. No. If you're objecting, we'll consider it today only. No problem. We'll hear it today. You be there. Mister, you will have to establish your right that the contract for labor contract has to be given to you. They don't have the power to make a direct recruitment. If that is not there, I'm dismissing you. So better let her have her instructions.
Your Lordship, this matter will be listed on 29, Your Lordship.
Fix on 29.
This 29.
Oh, we'll have it next week. We'll have it on third. Three. On the prayer of Mr. R.H. Nabam, learned additional advocate general appearing for the state respondents, registered to list this matters again on third, 3/6/2020.
Organize your lordship.
May I please, Your
Yes.
Lordship? I like to mention item number 25. I may be allowed to withdraw.
25.
Yes. Since the matter is already settled out of court between the parties, so I may be allowed to withdraw.
This was a delay condonation petition, right?
Yes.
IA
I along with main,
also. Mr. D. Boy, learned counsel for the petitioner on applicant, IMA money. Applicant submits on instructions that he be permitted to withdraw the present petition. Full stop. A present interlocutory application. Full stop. Prayer is not objected to by the learned counsel for the opposite parties. Full stop. In view of the above, the interlocutory application stands dismissed on withdrawal. Full stop. Consequently, the regular first appeal being RFA number 10/2024 also stands dismissed on withdrawal.
highly obliged.
Your Lordship, I'm selling appeal order dated 17/3/2025. Passed in this case number 23 of 23. Which is at page number.
17/3/25 order you are aggrieved to.
Your Lordship. Your
Give me the reasons.
Your Lordship, plaintiff bank had filed one issue before the learned trial court, and I had appeared before that. So at this stage of WS, I came up with application for rejection of plan, saying that the branch manager, who is in a representative capacity, must have annexed his authority letter along with the plan, which is the mandate of Order 7 Rule 4 of the CPC. So until and unless that is annexed with the plan is bound.
They filed a written statement there.
Your Lordship.
And therein they have brought the gazette notification.
Your
It
Lordship.
says any document, anything, it's permissible for him to execute.
Your Lordship.
Page 74, 75 of your paper book.
Your Lordship. So
After that, what is there? What do you have to say?
what I had tried to advance before the learned tribunal was that this document has to be annexed along with the plan.
Need not be. It's a gazette notification.
Yes.
It's a general devolution of power. Why should that be brought on record? It's a general devolution of power.
You know, that part is okay. You know, the plaintiff bank.
77. Come to page 75. That clause 77.
Your Lordship.
Plain's written statement. Have you got it?
Yes.
Read that.
Yes. A plaintiff's written statement, petition and application may be signed and verified. Affidavits may be shown or affirmed. Bonds may be signed, sealed and delivered, and generally all other documents connected with legal proceeding, whether contentious or non-contested, may be made and completed on behalf of the State Bank by the chairman or by any officer or employee, and empowered by or under Regulation 76 to sign documents for and on behalf of the state.
So 76.
Yes.
It is general power given even to the branch manager.
Yes.
So why should there be a separate document? That is enough. You dispute this, that this is not there, then we will examine.
Your Lordship.
If the power is given, it's delegated. For everything, you need not bring that on record.
Your Lordship.
It's already a general power given.
Your
The
Lordship.
branch manager is authorized.
Your Lordship.
So there is no further. You raised a dispute, but they have answered it. After that, what is more left? What is the error in the order then? There is no error in the order against which you have filed this revision.
Your Lordship.
Hmm?
You know, my contention before the learned trial court, since,
Contention has been considered
yes,
and rejected.
yes.
What is the error?
And your Lordship, I'm allowed to withdraw this.
On, you're a young counsel. I ask you two questions. Why are you withdrawing?
Your
Fight the matter out with me.
Lordship.
Or make your submissions.
Your Lordship,
That's the easiest way out.
yes, first,
Make your submission.
yes, first plaintiff bank, being a banking company, under,
Banking company, every banking company has its own regulations, rules, and
Yes.
this is a statutory company. There
Yes.
is an act.
yes, Your Lord,
Under that act, there is a regulation made.
yes,
In terms of that regulation, power is also given to the branch manager to sign documents, even sign planes, any legal document.
yes,
So he has the power to institute proceedings.
yes,
Now, that power being conferred on him, he has not made any error
yes,
in filing that plaint. He does not require any approval.
yes,
He has filed it.
yes,
You raised a query.
Yes.
Right? The learned trial court
yes,
considered that, considered their grievance, considered their reply and came to a conclusion, yes, in view of the gazette notifications,
yes,
nothing, gazette notification is known to all. You need
Yes.
not bring it on record in every time. It's there.
Your Lordship, Your Lordship.
That-
Your Lordship, Order 7, Rule 4. There has to be aberment in the plan to that effect, that I have been authorized, general authorities there.
Maybe not there.
Para,
You have
para 1
taken
of the
the,
plan. Page 32, Your Lordship.
to be represented by its senior branch manager. Fine. What error? What error? No error. Yes, madam, you are paying for?
I'm,
You are paying for whom?
SBI.
Your Lordship, if they affidavit, let them come.
Come to page 67. It's this categorical stand. And that stand has also been considered by courts and it has been upheld. Page 67, second paragraph onwards. Read it for your
Yes,
satisfaction.
yes. To clarify foregoing point, it is further back to state that by the Gazette of India, May 2, 1987.
All branch managers.
Yes, all branch manager has been empowered, authorized to sign all documents, instrument, amount receipt, letter and advice, etc. connected with current or authorized business of the bank in respect of all matters coming in discharge of function of the post held for the time being. Apart from this Gazette of India, May 2, 1987, under the provision of 76 and 77 of Regulation of SBI General Regulation 1955, as amended by the State Bank of India General Amendment Regulation 2013, the branch manager has been empowered to sign plans, written statements, swearing affidavit, etc. on behalf of State Bank of India. In the State Bank of India versus Kashmir Art Printing Press, Sirsa, on 12 February 1981, the PNH High Court held that the branch manager of respective branches of the State Bank of India has an authority to engage a counsel and to sign the wakalatnama and the presentation of plain by the advocate is proper institution of the thing.
Where is your application amount? Order 7, Rule 11D and F.
Your Lordship. Your Lordship.
So, what do you say now? You satisfied that there is no error?
Your Lordship, if Order 7, Rule 4, what I'm trying to advance, if it is not mandatory, then I may be not. Otherwise, my whole case rests upon.
Okay,
Order 7.
some CPC. Order 7,
Order 7, Rule 4, Your Lordship. May I read?
this will have no application. This is not a representative character suit. It is sued by a body, corporate body. The only thing is who will represent that body. It's State Bank filing. It's not on a representative capacity. It's State Bank who is filing that. It's a body corporate. So it cannot be in a representative capacity. Its only question is who can represent the State Bank of India because State Bank of India can't come and sign.
Yes.
Somebody will have to sign on its behalf. That authority is already devolved to the branch manager.
Your Lordship.
So that is a statutory regulation. That a gazette notification is also there. Gazette of India nothing more is required.
Your Lordship.
Now what do you say? Are you satisfied?
Yes, yes.
Then I am permitting you to withdraw. Mr. Teach, and leave this habit of asking for withdrawals when a query is asked by the court. Last time you are making that.
Your Lordship.
Mr. T. Chise, learned counsel for the petitioner, after attempting to argue the matter at some length, submits on instruction that he be permitted to withdraw the present revision petition. Also, prayer is not objected to by Ms.
Why Karga?
Waikala, learned counsel representing the respondents. Also, in view of the above, the present civil revision petition stands dismissed on withdrawal.
Deep blue.
Argue, fight it out always.
Must have lied.
Yes.
My lord, I am just raising this issue regarding the jurisdictional errors of the village authority. And you see,
Inter-village kabang, the power is not there. It's an appeal now. It's appeal. Direct original jurisdiction is not there.
no, yes. The respondent has filed a complaint before the inter-village authority, and the inter-village authority has decided the dispute in their favor, in favor of the respondent. So, my lord,
Where is that 911 and 1011?
it is in page number 18. And type copy is page number 19.
But this is by the village level committee. Page 19 is by the village level committee.
Decisions, yes, decision given by the Bango secretary.
Bango means here, Dolong Bango Payung Village Society. It's a village.
Society is there, but that has to be decided, the dispute has to be decided in the village authority, not before the Bango village, Bango secretary.
What is the difference between a Bango and a village society?
Village society, because as per section 5 of the AFR, the village authority is appointed by the deputy commissioner, and the village authority has decided the dispute of the village, certain village. But Bango level Kaba is
So where is the next one? Kebang decision?
Kabang
Page
decision,
25.
page 23 again. After adjudication of the Kaba, again on 10/11/24, again that disputed land which was adjudicated, they again divided the land into 50-50.
Okay. Your name?
G. Lolen.
Hmm?
G. Lolen.
G. Lolen, learned
Yes.
counsel for the, heard Mr. G. Lolen, learned counsel for the petitioner. So the present revision petition has been instituted, assailing the decision of the Payam Dolo Bango, dated 9/11/2024 and 10/11/2024, on the ground that the said decisions were arrived at pertaining to the dispute regarding land by the said body without jurisdiction. Also, it is submitted that while the Kebang decision of 9/11/2024, while the right of the appellate of the petitioner hearing of the respondent hearing was Apang Tachung is the respondent.
Yes,
And where is the decision in your favor?
the decision not goes in my favor, it goes in favor of the respondent. So I will agree with this decisions.
So this 50/50 is a development.
Yes, new development. And another, this Apang Tachung and Sri Takar Tachung. This 50/50 land has been divided. I am not the party in this case.
Without jurisdiction. करके छोड़ दिया. Full stop. Issue notice returnable 4 weeks. Full stop. Petitioner to take steps for service of notice upon respond number 1 and 2 by way of registered post as well as by way of usual process steps within 3 working days from today. Also issue notice on the interim prayer, also returnable after, आगे ऊपर ना कितना notice कितना दिया था? 4, after 4 weeks. Full stop. Any further decision, any further steps taken in pursuance to the decisions of the Kabang dated 9/11/2024 and 10/11/2024 would be subject to further orders that would be passed on the returnable date.
Interim may be granted. Please.
Returnable date. You come back.
Yeah, please, my lord. Sir, this is a bail application filed by the applicant is the father of the accused. Will you kindly come to page number 16, 16. This is the initial FIR.
Okay, we'll issue a notice.
Yes.
Heard, Mr.
S. Chetri, my lord.
So and so also heard, Mr.
Deloy.
D. Loring, Learned PP, appearing for the state respondent. The present application has been filed invoking provisions of section 483 of the BNSS 2023 for grant of regular bail to the accused Nairi Tugu alias Nanu in connection with Women Police Station case number PS case number 34/2025 under section 137 bracketed 2/3 bracketed 5 of the Bharatiya Nyay Sanhita bracketed BNS 2023 read with section 4 bracketed 1 of the POSCO Act 2012. Issue notice. The learned PP shall on the next returnable date produce a scanned copy of the case diary. So, petitioner, petitioner to take steps for service of notice upon the respondent number 2 by way through the jurisdictional, through the office of the public prosecutor, Itanagar bench, Guwahati High Court, Itanagar bench, for service of notice upon the respondent number 2 through the jurisdictional police station. To the jurisdictional officer in charge, to the jurisdictional police station. Full stop. Steps be taken within 3 working days from today. On the returnable date, Mr. The learned PP shall furnish, shall produce the case diary.
My lord, it may be fixed on 2nd in that 2nd of June.
Too short. Too short. After kitna din diya? Register to list this matters again on 9. Vehicle has been recovered.
Yes, Lord. Lordship,
Yes, what do you say?
in fact, the accused was engaged as on daily basis driver. Only he has been paid 2,000 rupees.
But lordship here, they didn't wait to wait for the CD in the,
You produce the CD.
yes, sir.
When? Second?
Scan copy, Lordship.
Scan second?
Yes.
Yes.
2/6?
Okay. Can it be on Friday, Lordship?
So,
Because it's.
Friday, this fourth may not be there, that's why. Monday, Monday or Tuesday? Tuesday.
we eat
Second.
4 Lordship.
Huh?
We eat the 4 Lordship.
4.
Yes, Lordship.
4.
4/6.
As prayed for by the learned PP appearing for the state respondents, registered to list this matter again on 4/6/2024. So on the next date of listing, the learned PP shall furnish the scan copy up to date. Scan copy of the up to date CD for a price for perusal by this court. So,
God bless.
what happened to the criminal case?
It's pending before the special court.
Yes,
Lordship, I'm appearing on behalf of El Perme.
Perme. When is Mr. Perme coming?
He is engaged in other court, Lord.
Is engaged in other court. Ask him to complete his instructions. We'll have this matter on Wednesday next. Suspension, concept of suspension can come in. But you have now directly terminated. Tomorrow he gets acquittal in the criminal case, what will happen?
Then maybe,
Mr. L, Mr.
yes, Hirang on behalf of El Perme.
S. Hirak Learned Counsel appearing on behalf of Mr. L. Prame, Standing Counsel, Agriculture Department, Power Department, Department of Power, submits that he would complete his instructions in the matter on the, by the next date of listing and apprise this court of the stand of the respondents in the matter. Full stop. Accordingly, the registry to list this matter again for motion on 4/6
Yes.
on 4/6/2024. Full stop. We'll pass orders, let him know this. No point in keeping it pending. We'll finish it off. 4/6. Mysterious section 16G.
My lord, that is the only ground.
Yes,
Lordship,
satisfy that you have 16G.
Yes,
We'll
sir.
ask Mr. Majumdar to leave early for Bertie.
Yes, my lord.
Clerical
Oh.
error.
It's the clerical,
Clerk.
typographical error.
Close.
What is the provision?
This is 15.
15. Yes.
This is the Lordship forwarding. This is a memo forwarding Lordship to the higher authority. Lordship will find Lordship.
Lopa. Where is the Lopa? Where is the?
Lopa is at third page, Lordship. It's serial number 12, Lordship. 12/4. Lordship will find serial number 1.
Financial turnover not up to date.
The second is the Lordship GST return. File
Where
not
is the
up to date.
condition?
That your lord will find at page 36.
36.
If it, we were thinking that it may be 15 because there is no 16. But 15G, you'll actually find at page 36. GST registration certificate and acknowledgement of up-to-date return filed as per NIC tender with stipulation. Now, our tender documents are actually find from page 147. Whether,
Now, this would be till the calendar. They follow the calendar year.
yes,
GST? GST follows the calendar year or financial year?
I think, yeah.
Calendar year.
It's depend on the scheme which he has set up, quarterly or annually or Lordship half yearly. His is Lordship quarterly. Lordship.
Quarterly. So he will have to give
By
till-
March, Lordship, yes.
till March he will have to give.
Yes. Whereas he, what he has submitted is up to December.
December
2024.
24. No due certificate from Apex Bank issued by so and so. Only this condition. And what is that financial turnover not up to date?
Lordship, that part has been Lordship in a higher Lordship approving authority. That part has been Lordship
Negated.
name.
Only this GST party.
GST, this is mandatory.
Yes, Mr.
Madam, page 147 is the starting page of my documents.
What happened? Has the work been allotted?
Lordship,
Financial bid not
it
yet
has
open.
been already open, financial bid has been
Opened.
open, and one, Bruno
Bruno.
has been.
Bruno is the only other responsive bidder, my lord.
Yes. What do you want to show from here?
Well, page 147, serial number 10, you'll also find we have given a gist of documents we have submitted.
Okay, where
Yes.
is that corresponding document?
That's the page 167, my. This is the certificate.
No, this is your GST registration,
Registration. They want registration and the return.
return.
Return is at page 170, my.
This is still October. You are giving it quarterly.
Now, whether I'm giving.
Yes, because it's come to the period October, December.
This is up to October, yes, October, December.
December, January, February, January, February, March.
No, this.
And when was the
this-
tender issued?
On 15th of April, Lord.
15,
Lord.
April 25.
The 10th of April.
10 of April,
The last date of submission is 16th of April.
document. And what is the last date of submission of a quarterly return? I think it's not, it's after that period. Mr. Muzumdar, what is the period for submission of GST returns, quarterly returns?
For
Date?
that, I have to take instruction.
Just have your instructions on that.
2
When
o'clock, 2 o'clock.
you'll be here.
2 o'clock. Well, I've got another matter before your lordship, pending matter.
Just have that instruction.
Smile.
But that's the only point.
Only point.
Two. First, call this item. And what is your another item?
There's one, I think, 28, I think.
31.
31. That can be disposed of possibly one interpretation of one particular provision, section 15 of this Arunachal Pradesh Civil Codes Act 2021 is involved.
Hmm.
What has happened, my lord? KEBA has taken a decision.
Hmm.
Then we file an appeal.
Hmm.
After that intervening period, we just file an objection before the deputy commissioner.
Hmm.
Then new act came into force. Then that objection was sent to the district judge.
Hmm.
District judge has now sent back it to the senior judge, civil judge, senior division.
Hmm.
Now there in the appeal, the other side has taken, is there, has taken a plea that this becomes a second appeal now. The appeal before the civil judge junior division was the first one. This is a second appeal. Now, second appeal is not maintainable.
No.
Section provides only appeal against the original
Order.
decree.
Hmm.
That is the plea they have taken.
Hmm.
I'll try to distinguish, my lord. If your lordship otherwise not is satisfied, my lord, then the matter will go back to the authority. We'll have to file a revision against that order before the Supreme.
Because I think we have already taken a decision, call on this sort of a matter, some decision on this.
One judgment is there by Honorable Justice Barua. Devashish Barua, my lord. One judgment.
Maybe, and
That
I,
I'm having, but that is not really.
no, I think I have passed an order.
My lord.
Mr. Kaushik was, Vedanta Kaushik. Order. Just find that out for him.
Yes.
Similar issue.
It can be disposed of, my lord, so that.
2 o'clock.
My lord.
You asked Mr. Dickey to be here, so we will take up both these matters.
My lord.
Subject to others not object.
My lord, always. Yes, instructions are like this, that so far as the petitioner is concerned, actually earlier the same tender was floated earlier. It's a subsequent transfer after corrigenda. Earlier, when the tender was floated, I submitted my bid in the month of February, and that is what was evaluated. This is number one. Secondly, my lord, even if it is subsequent person to the present NIT, the period during which the bid has to be submitted is from 10th to 16th April, I think. And the GST return for the first quarter is to be submitted from 20th April onwards.
So,
But what I have instructions, what I have received is Lordship, the last date is Lordship 20. From 1 to 20, it has to be filed. And 21 was.
no,
after-
if he is not required to file the GST returns
Lordship,
before 20th of April,
Lordship.
then the last quarter, according to him, would be this October, December.
No, before January to March lawsuit.
That's it. That
He has to
quarter.
file on or before 20 of lawsuit, April.
Huh.
He could have filed it.
He could have, but where is that legal bar?
But we have sought for lawsuit, updated lawsuit return. Updated return means lawsuit, the latest one.
Latest legally filed one. That would be October, December.
That is not the latest one. Because
Mr.
quarterly
Mr. Ravin, you are not getting my point. What I'm trying to say is
lawsuit.
updated would be the one which he has to legally file.
Legally filed.
So legally his, the January to March quarter
Lawsuit.
would be required to be filed by after 20th,
It
No,
says,
no.
now I have got the
From
document,
1
it's
to 20.
after 24th.
24th of
There is
April.
a list of states which are allowed to do it.
Ah.
This list includes Arunachal also, Jammu Kashmir, Ladakh, Himachal Pradesh, Punjab.
Because there he has to get his input credit, that things are uploaded,
Lawsuit.
list one, list two. There are many formalities
That
involved.
is their lawsuit.
So if
But
that be so,
No, you know, anything to show that it has to be filed after 20 days.
no, we'll ask them to file an additional affidavit to
Yes.
that effect. You also get only on that point.
Yes.
Mr. Majumdar,
Yes.
you file an additional
From my lord,
affidavit.
yeah. It is available now. I have got it from
You
the
file
CA.
an additional affidavit,
Yes.
you come online. You
My
will
lord.
not take the
My
trouble,
lord.
you come
Day
online.
after tomorrow,
But only problem is Friday,
Thursday, madam.
Thursday,
Thursday. Fine.
Thursday.
Lawsuit.
As agreed, heard the learning council for the parties at length, as agreed to by the learning council for the parties, registry to list this matter again on Thursday date to review. The learning council for the parties are at liberty to bring on record additional, learning council for the petitioner is at liberty to bring on record additional pleadings in support of his case, full stop. Further, Mr. Tapin, learned senior government advocate, is also at liberty to receive written instructions with regard to the manner in which the authorities have interpreted the tender conditions, more particularly condition as prescribed in clause 15 bracketed small g of the MIT.
No.
Registry to list this matter on so and so as a fixed item. Thursday.
They will not proceed further. They have still, they say.
We'll have it on Thursday. You have that thing filed so that we get it and
Yes.
you can come online. There is no
My-
problem. Only on that point only, no?
Only one point.
Otherwise, we'll have to follow that Supreme Court judgment that they are the author, they will have to.
Best judge.
Yes, sir.
Best
They
judge.
can't go beyond that.
No.
Yeah, please, Lordship. Lordship, this matter may be listed after 2 weeks, Lordship. Lordship, as Lordship, leading counsel, Mr. T. Jamoy, he's out of station. Lordship, for his, due to his personal matter. Lordship.
You're working now as Chief Judicial Magistrate at Roing.
No, Lordship, I'm
No,
not
no.
respondent, Lordship.
You're for the respondent. Okay. You're working as
Yes, Your Honor.
Serastadar at the office of the Chief Judicial Magistrate at Roing.
Yes, Your Honor.
What is the district judge court there? What is the name? What would be the term district judge court? It would be Lohit district,
Yes, Your Honor.
Tezu,
Lohit.
district judge.
Hmm.
A prayer is made on behalf of Mr.
T. Jamoy, Lordship.
T. Jamu.
Lordship, my name is reflected there, Lordship, in causeless. K. Tabang, Lordship.
No, we are making this prayer on behalf of
T. Jamoy, Lordship.
A prayer is made on behalf of Mr. T. Jamu. Learned counsel appearing for the respondent, no? Respondent,
Lordship.
for an adjournment today on account of personal inconvenience. Prayer is not objected to by the learned counsel for the appellants. Also, for the petitioner. Full stop. Registry accordingly to list this matter again after
2 weeks, Lordship.
2 weeks on a date to be fixed by full stop.
Interim may be continued.
Interim order passed earlier to continue till the next date of this.
They will, Lordship.
Yes, Mr. Majumdar, Mr. Pine, you are ready with that matter?
Yes,
But there is a judgment. I think I have delivered one judgment.
Your judgment possibly sharing in
I don't know, I forgot.
one of this.
One. Oh, this is different.
Slightly different,
This
actually.
is slightly different.
To my
Here,
understanding,
a
my
fresh
lord,
plate was submitted.
to my understanding, my lord, the statute is clear. 15.2
Hmm.
has to be from an original decision of the civil judge.
Hmm.
Apparently, the civil judge senior division exercise appellate jurisdiction
Hmm.
from a decision of the village authority.
Hmm.
So now, the district judge conferred jurisdiction upon himself. That is a legislative function. He can do that.
He can't do it.
Yes. In
So
my
what
opinion,
is the way out for him?
What my learned friend is saying is,
227, I believe.
initial decision was of KEBA.
Hmm.
Then, before the 21 Act came into force, we filed an objection before the DC that remained pending.
Then that was transferred.
That was transferred to the district judge. Now, district judge in turn transferred it to the civil judge senior division. Civil judge junior division. Senior division. Civil judge senior division. Civil judge, it was decided as an appeal. Thereafter, we preferred an appeal before the senior district judge.
That he contends
That
would be a second appeal.
Second.
That was
cannot
filed
be.
under 15.2.
52. Lord, let me just have a look at 15.
I'm giving the list of this because I don't bother the notes here.
Where is that act, the latest one? 15.
Act your lordship will find at page 24 of the CRP. Your lordship may kindly have the definitions first. Customary code 2D. Customary code means code of a traditional council or authority of a village indigenous to the state by whatever name called, and includes a code of village authority. Now, village authority might not exercises jurisdiction might not without any pecuniary limit. Customary code. So this is the exercise that has been conferred by way of an act. Now your lordship sees 15.2 under which the appeal was filed. At page 26. 2. Appeals from the decrees and order passed by a court of civil judge senior division in original suits and proceedings of civil nature shall, when such appeals are allowed by law, lie to the court of district judge. So it should be an original suit of a civil nature. Then it will go to the district judge.
So this proceeding,
Yes.
it's not in a civil nature. Customary court appeal that he is hearing, it's not in a form of a civil court.
No, it is a civil code.
It is a civil proceeding.
Yes, civil proceeding.
Then why this last proceedings of civil nature?
Including proceedings of civil.
Yes.
Civil nature. If that be so, then the order that is passed by the senior judge,
Yes.
civil division senior, civil judge
judge
senior division,
yes.
that then an appeal will lie to the district judge.
No, my lord, this has to be read together. It's original suits and proceedings of a civil nature.
So why, how this and is to be? Original suits and means,
Proceedings of civil
proceedings of nature in a original suit. That's what
Yes.
you want to say.
Yes. If the suit was directly filed before the civil judge senior division, my lord, of a civil nature, my lord,
Then he will.
then it will go under 15.2 to before the district.
If it is a proceeding before a civil judge senior division, can it be anything other than civil proceeding?
No, my lord. But the act is, my lord, unbelievable. In fact, the latest amendment, it says appeal from the village authority will go to the first judicial magistrate, the chief judicial magistrate. Now, this is to me, my lord, we can only, my lord, interpret this because of the language used in the principal act and the first amendment. That is how careless the state is.
It has made it a criminal proceeding.
Yes. They say it go to the civil judge, first class magistrate, then chief judicial magistrate, then they said district and sessions judge.
Nobody has challenged that.
No, my lord. In fact, I just saw it, my lord. 2023 amendment.
Otherwise, the matter has been sent back for de novo trial. And the village authority has decided without taking into consideration any evidence, anything. That way, the appellant will not be petitioner will not be prejudiced by it with the merit of the case.
If your lordship's my lord, exercise 227 jurisdiction, my lord, set aside the appellate decision of civil judge senior division on this ground, my lord, I cannot have any objection, my lord. But, my lord, the fact remains, once there is no jurisdiction, my lord, the court cannot assert jurisdiction. It will be nullity.
Where is your prayer?
My lord,
Your prayer here?
my prayer. Page 19 starts.
Okay. So you mean to say that once the civil judge senior division passes an order, then
Exercise
the only
appellate
option available is 227
Yes.
revision?
That's what they are saying. But
What,
then,
what do you have to say?
well, first is, as your lordship is indicated, it says civil judge senior division, the 15(2), subsection 2, appeal from the decrees and orders passed by the Court of Civil Judge Senior Division in original suits and proceedings of civil nature. If only proceedings of civil nature expression is taken to be proceeding against which I am coming, then there is no bar.
But my lord will see, my lord knows the proposition, my lord. When there is some ambiguity, the heading, my lord, has to be taken into consideration. It says appeals. 15. It's clear, my lord, appeals.
I think we'll have to consider this a bit more deeper.
Because it says appeals.
And one provision, lordship, will just have a look, my lord. 2022, there was an amendment.
Where is that amendment?
22 amendment.
22, 22 amendments. Yes, my lord, it is, he has annexed it. Lordship will find from page 30 onwards. The second proviso of section 3, subsection 4, my lord. Or it is, yes. It is good. Page 31, my lord. Page 31, Roman 3 is there, my lord. After the fourth proviso to subsection 3 of section 15, the following subsection shall be inserted. 4. An appeal from the village authority is agreed to by the parties shall lie before the inter-village territorial customary court or apex customary court by whatever name called, which shall settle the case as per the local traditional customary laws under the provisions of section 40 of the regulation 45. Then first proviso, provided that an appeal against the order of the inter-village territorial court or apex customary court shall lie before the courts of civil judge union division, the courts of civil judge senior division, the courts of additional district judge or the courts of district judge, as the case may be, as per their territorial and pecuniary jurisdiction. Last one is important. Provided further that the courts of civil judge union division, courts of civil judge senior division, courts of additional district judge or the courts of district judge, as the case may be, shall not set aside an appeal so filed merely on technical ground or procedural lapses, but in the interest of justice shall dispose of the same as may be deemed appropriate or proceed with the case deemed. So if this provision is given a meaning that even if there was some technical ground, the ultimate order that was passed is de novo trial, nothing else. Nobody was given any writ. Possibly, my lord.
What was the order passed by the civil judge?
This will apply to the, my lord, first appellate court, not to the district judge.
No. What was the order passed by the civil
Keba.
judge senior division?
Keba
The
decided
Keba decision was
50-50.
FR.
Divide. Yeah,
So that was set at not by the district judge.
yes. Directing the parties.
2006 Keba.
So your case is that the district judge could not have assumed jurisdiction
Yes.
when the act did not
Yes.
provide for. 15(2) did not.
Yes.
provide. Whereas Mr. Majumdar would try to contend
Yes.
that this being a hierarchical court,
Yeah.
a judgment which is permissible to be taken up on appeal from the district civil judge, the district judge did not act beyond his jurisdiction. He acted in its normal course of his power conferred upon him.
Well,
Now
don't-
tell me one thing,
Ma-
what was
My
the
lord, see,
manner in which the suit before the the objection of the deputy commissioner came to the district judge.
yes,
He remanded the matter to the
civil judge.
civil judge. How was the case registered before the civil judge senior division?
It was on the basis of the remand by the
No,
district judge.
what was the manner in money suit, title suit?
No, it's an appeal.
Where is
It's
that?
there in the order itself. Just a moment.
It's a title appeal. What is it?
Just a moment, madam.
Civil appeal के बाद
Page 87, I think.
No, ma'am.
Civil appeal.
senior division.
Page 86. Civil appeal kaba number 4622.
So it's under a special authority, they are hearing this. And what is this title suit at page 52?
52. Minor, this were minor misconceived titles was filed by both the parties.
Oh,
Both
this
of them
was
were-
that, this was one which was dismissed on res
both of-
judicata.
Yes, both of them filed.
Okay.
My client also filed, the senior friend's client also filed.
Any decision on this point
Minor,
of this court? Any decision on this point?
regarding?
This issue?
No.
No, madam.
And to my knowledge, no, because
No,
one
not
judgment
yet.
by your lordship, which I have just.
That is different.
Another judgment is by Honorable Justice Barua,
Can have that.
that is also not relevant.
No,
That's
not relevant.
touching upon this issue.
This is the first time this issue has come up.
Okay. Heard Mr. D. Pani, learned counsel for the petitioner, also heard Mr. D. Mojumdar, learned senior counsel, assisted by Mr. C. Gogoi, learned counsel appearing for the respondents. So the parties have made their respective submission, however, the hearing remains inconclusive. The registry to list this matter again. We'll have it on Tuesday, if not otherwise, you will not come, you can
My lord.
join online Tuesday. Mr. Pani, I'll just go through it once.
Madam.
On 4th, huh?
Under
Post-
there are Supreme Court judgments when there is some confusion regarding a statute, the heading it has. to be-
If there is any decisions you want to rely on, just give it to her.
Yes,
I'll go through it. Tuesday, we'll have a call.
madam.
Tuesday.
Because this is the first time. So
My-
Yes.
let me just examine it. Mr. Majumdar, you don't take the trouble of coming, you can,
In the list,
provided it's
No,
not
no, my
otherwise
lordship,
prejudicial
lordship-
to you.
Your lordship may not
list
think
of
about
court
it.
matter have given
I'm
the
always,
facts.
I'm always
No,
comfortable.
no, I told him if it is not prejudicial to his interest.
Now,
coming
it is
on
my-
with-
today, when there are more than one, because I now accumulate and come only once in a month. I cannot take up this journey.
Oh, blood.
I'll be very happy.
Better.
Better now, madam.
Then
It is
we used
better
to
than-
come, the
yes.
olden days,
There are
9, 10 hours. Now it takes
Exactly.
4.5 hours.
highest time that I took once about 10 hours, as your lordship.
9, 10 hours.
Yes.
Was, I mean, maximum.
Through Bandar.
Earlier.
Through Bandar.
Yes. Now
That-
5 hours.
that has
5.5.
come
4.5.
Yes.
Okay.
Oh, blood.
Your Lordship, may I? Lordship, connecting counsel, Miss Artaku. She is not available. She's out of station due to medical ground. Kindly, this matter may be adjourned for today and may be listed after 2 weeks.
Mr. Tama is having a lot of problem here. He is very seriously disputing your conduct. He wants to do the matter.
Last order, lordship, on the consent of,
Yes, Mr. Ate, what is here?
the order passed by the learned, your lordship, the CGM, your lordship. According to me, your lordship, it was in accordance with the provision which has been provided by the AP court, your lordship. It is rightly, your lordship.
If
which have-
something lost, and who are you? You are, it seems that you have been projected by the contractor.
Actually, contractor, we are contractor. I am also contractor.
You are the sub. The main one is behind. He is not come forward.
My lord.
Huh? And at least the lady who has done it, she is a civil servant. So prosecution is mandated. 1. 2, there is a rightly or wrongly. How can there be a criminal thing here? If there is something lost, you go for damages claim. No, my lord. I don't find any error in the order.
It is there, my lord. Yes, because the removal of that partly constructed that house. That
Who is
No.
saying that? Now, who is saying that that should not have been? The government is not saying, it's your projection. You say that the government had cleared that project, so you were under the process of construction. Mr. X was there, he gave the work to you, you were continuing with the work. Now, which is the government authority saying that the accused or the accused number one in demolishing that house had violated something? Which
Because-
governmental authority has made that plea?
because, my lord, since that work, it was awarded to the principal.
I understand. You damages, you have your right to get that work completed and also receive your remuneration therefrom, or the cost of that is been scuttled. So you have a remedy, you file a civil suit for that.
But then since we have lodged the FIR, and since the
And FIR lodged, rightly the learned trial court has passed this order according to me.
to my understanding, my lord, is because the provision, that is immunity provision, my lord, which it was invoked, is not attracted in this case. If we go by the section of Arunachal Panchayati Raj Act,
No, if there is a violation of the Assam Arunachal Pradesh Panchayati Raj Act, by which the contract given to you has been eclipsed, you file proceedings for compensation.
but then, my lord, in this way, if someone takes law
That
in
is different thing.
their own hand, because, my lord, what they are claiming is that they are immune from prosecution as per
That we are
Panchayati
not
Raj
going
Act.
to.
But then that could have been, my lord. Had it been that the structure which was removed, that was within the area of that school, my lord.
Okay, now one more thing. If we go a step further, this structure was constructed in a public place.
No, my lord.
It is a private place.
It is a private place, my lord.
It is
Therefore,
a
my
not-
lord, I am
no,
saying
no, it is not a scheme of the government,
this is a scheme of government, but then
It is for public purposes.
public purposes, my lord.
So where is the sanction or the authority received from the Gram Panchayat for this construction?
Kindly come to, my lord, financial sanction order, page 24, my lord.
20?
24. This is the financial sanction order, my lord, issued by the Department of Finance, Planning and Investment. And the project, kindly
Your
come to
project
page
is
25,
264. Serial number?
264, correct. So accordingly, my lord, page 26 onward, work order it was issued. And not only this work order, lordship, kindly come to page 39. Additional Deputy Commissioner has issued this order as per the survey report submitted by Sri so and so JEPW. The community hall of the Hemi village is in the verge of collapse and unfit for the use of the denizens. Therefore, the undersigned directs Sri so and so JEPW dismantle the said structure so that the new structure can be developed in the same site. So it was demolished, and then we have started constructing the structure. All of a sudden, this groups, alleged accused person, led by that lady, they demolished the structure.
But there, rightly, wrongly, there was a Sabha decision for that.
That is not Sabha decision, my lord. And, my lord, therefore I'm saying, had it been, is because they are saying since that construction was within the premises of school.
You say it is outside.
Yes.
some distance away.
As per the investigation of IO, it is outside. But in learned trial court below, my lord, have made the observation that was within the school premises while discharging them. And therefore that immunity comes, that Panchayati Raj Act, section 244 or something, that he cannot be prosecuted. And if 161's statements are various, my lord, there was a rival claim that actually this lady,
No, this basically is a civil dispute.
but then, my lord, demolishing the public property, my lord, whosoever she may be, but then taking law in our hand, my lord.
Now, where is the complaint by the PWD?
Complaint by the, my lord?
PWD. Because PWD had asked you to carry out the
My
work.
lord.
Where is the complaint by the
They have not,
PWD?
they have not lodged the complaint.
Then, where is the complaint by the concerned line department?
My lord, this is FIR.
Because you are just a contractor.
My lord.
You are just a contractor. If they don't have any problem, why will you have a problem?
It's not that they do not have any problem. my lord.
It's not reflected.
But then since I am a contractor, when it was under some project, if someone dismantled, then
No,
this is
it
my
is-
duty
I
to lodge
got it.
FIR.
But where is the investigation made by the police with the concerned authorities? Because the matter flows from there. Yes, Mr. Ate.
Yes, madam. Your Lordship, the section 32, Your Lordship. It says, Your Lordship, no person shall erect any structure, new building, or make any addition to any structure or building in any area within the jurisdiction of Gram Panchayat, except with the previous permission in writing of the Gram Panchayat.
It's not there.
Yes, not there. Every person seeking permission under subsection 1 shall make an application in writing to such authority in such form, so and so, so and so. Provided that no permission under subsection 1 shall be necessary for erection of any stretch structure, tin shed or tile shed without brick wall covering an area not exceeding 750 feet. Further, the state government may by order exempt any structure or building or any class. So exemption is also not there.
Section
32. Prior permission is required, Your Lordship, and it's fall under the jurisdiction of that Gram Panchayat.
What is that act called? Panchayati Raj.
Yes, Your Lordship.
Panchayati
It's Arunachal Pradesh Panchayat Raj Act, Your Lordship, 1997, Act number 5 of 2001.
Yes, Mr. Dama. And this is just a sanction. You will have to meet all the requirements. Thereafter, the work should be executed.
my lord.
You will have to meet the because it's here that it will have to be, all works will be awarded on the basis of page 24, basis of prevailing rules, government orders and observance of GFRI CVC guidelines. Okay. So, Mr. Tama, what do you say?
My lord, only because this permission, it was not taken. How come this, even?
They have the power, corresponding power to evict.
No, my lord.
Is there?
It's there.
In schedule 1.
Let us see this.
It's there.
It's there, Your
Because
Lordship.
it's already reflected in the order.
Yes.
What is the concern provision?
Schedule, Your Lordship, 1, section 30, general function, Your Lordship, is written. Schedule 1. Preparation of annual plan for development of the Panchayat area, preparation of annual budget, providing relief in natural calamities, removal of encroachments on public properties. If there is no any permission, then it will.
Therefore, now, my lord, kindly come to removal of encroachment
Hmm,
on public properties.
hmm,
Now let us come to charge sheet matter.
hmm. Hmm.
Whether that was in the public property or in a private.
It is a public property. If it is being made by the government, it is public property. It's not a private property, mister. It's not your own property. Is it your private property?
It says encroachment, but
That's
if
what I'm
suppose
saying.
someone
No,
construct
no, you
any,
are constructing a building without the, we are only on the narrow question whether the criminal proceeding is maintainable or not. Whether there is an offense committed by them. Now you are constructing this building not in your property. You are constructing it for the government. The government sanction itself says you will have to follow all rules, guidelines, everything. And one of the applicable guidelines would be the Panchayati Raj Act. Section 32 requires you to take a permission. You have not taken that permission. Maybe they exceeded their jurisdiction.
no, my lord.
Maybe
Since-
they exceeded their jurisdiction, but the offense is not made up. Criminal intent is not there.
To my humble understanding, my lord, it is there.
Naturally, you will have to argue that.
Because my lord, if someone construct any structure, like example, within the premises of this honorable court.
If it does, the registrar here will go and file an affidavit because this is our property without our.
Therefore, my
permission.
lord, therefore, my lord.
In
I
your
would say-
house, in your property, where
But-
your house is situated, somebody goes and makes a construction there
This,
without
my
your
lord,
permission.
schedule which my brother has ready to now.
It's just an indicative thing.
Ah.
We are only
It will be
examining whether
applicable
this-
only if
criminal
there is
thing
a
should be-
encroachment in the public property.
Now, where is this land? What is this land?
Kindly come to charge sheet.
No, what is that? Tell me, Mr. Tama, we only require,
Uh,
we have full faith on you. You just tell me what is this land?
it is in the land that is, somewhat distance near about 7 to 8
I'm
meters
not on
from
that. Let it be at a distance, but what is this nature of the character of this land wherein this construction was made?
It was,
Your private property,
no, my lord,
then,
no private property.
then what was that?
But then at least that was not encroachment, my lord.
What was that property?
That was, for construction of community hall, my lord.
So it is a public property. Property which the panchayat has jurisdiction. Because
But
it
my lord-
falls within their area.
That was not encroachment, my lord.
Oh, we are coming to an encroachment subsequently.
That dismantle part also, it was done by
Mr.
the
Tama,
PWD.
there is a land wherein you have made this construction. What is that land? Character of that land? Common land, private land, community land. What is it?
That doesn't fall under the jurisdiction of that school premises, but then
Forget
outside,
the school. We have forgotten the school.
it can be said, my lord,
If it is the school, it will be the education department, not the panchayat. So what is that land?
it will be public land.
So if it is public land, then they have taken a resolution. Be that as it may, rightly, wrongly, a resolution is there.
My lord, but then this is, scheme is under sanction by the government of Arunachal Pradesh.
Which governmental authority has raised a grievance here? No governmental authority has raised a
That
grievance.
is not there, that I
Yeah.
admit.
No governmental authority has raised any grievance here.
And regarding, my lord, the discharging in want of prosecution sanction, there is a judgment of our,
Prosecution sanction, we are not very much inclined. I'm only general thing. And tell me, the work order that was given to you,
my lord,
where is the prescription that this will be constructed at the so-and-so land bordering, measuring so-and-so, or where is the description of the land here?
my lord will find that at page 25 itself, my lord.
Hemi, it says,
Yes, care of community hall at Hemi,
Hemi.
Yomi district.
but where is that?
Case is, my lord, earlier there was a community hall that
Huh.
was in a dilapidated condition.
Hmm.
And that has to be demolished
Because
and
the,
reconstructed.
the the people, they have objected to construction of the community hall at that place. They wanted it at some other place. Right?
My lord, some portion of it.
So the desire of the people, that has to be given a way. When did you demolish the earlier structure?
That was demolished by JE. PWD.
When?
Kindly see that order again. Page 39.
5-4.
Page 39, my lord.
5-4.
5-4, correct, my lord.
And the decision of the Sabha was on 27-4.
27-4, my lord.
So within the short duration,
After 5, my lord, I have already started constructing, my lord.
without demolition.
After demolition,
Demolition, it took within a minute, it was demolished.
structure, my lord, maybe kindly see page 41.
This is the old structure.
No, new structure. After demolition, this is the new structure. Old structure, my lord, page at, that is at page 23, my lord.
20?
23, old structure.
No, it was a wooden structure.
Yes. The new structure is at page 41, my lord. That was demolished by those people, my lord.
You ask for compensation for the work done. That is the only thing we can do for you. Or if there is an alternative land, get along with that. Because this authority, executive engineer who has given you this work, he has got, was his statement taken by the police? 161 statement.
my lord. Be not here, my lord.
I did not find any government official, that's why I asked you.
No, my lord.
Then
Only 3 witnesses.
it is a private litigation. If the employer does not have any objection, how can the employee have an objection? You are an agent, agent of the agent.
That, my lord, if we.
Mr.
Go
Tama,
by-
you have a better thing, file a case for compensation. You are interested with your money,
My lord.
get the money in the way, in accordance with law. Yes. Why so hurry? Why so hurry in demolition? You're not in the matter. You're in the case.
Yes, I am.
You have signed the wakalatnama.
This case of my name is also reflected here, but it's been looked after by one of my associates. Even I don't have access to the file. So she's having for some medical issues. She's at Delhi.
Okay. I just wanted to see whether he has read the brief. When? Next week?
Yes, after 2 weeks. 2 weeks.
Invested so much time. We'll finish it off.
It's sorted.
Mr. Tama will be happy.
Yes.
It is. What is her name?
Taku.
Artaku.
Artago. Prayer is made on behalf of Ms. Artago, learned counsel for the respondents for an adjournment in the matter on account of that she is presently receiving medical attention for her ailments. Prayer is not objected to by the learned counsel for the petitioner, Mr. Tama, as well as by Mr. Ete, learned additional public prosecutor. So accordingly, registry to list this matter again. Give me a date. It would have been better. We could have it next week, but anyway. 16? Please give me a date.
25th June.
25/6/2024.
Highly advised.
But Mr. Tamam, okay, fine. On another day. Well, what happened to the other matter? Uh, That discharge case, maybe I heard and I passed a judgment. What happened to that? They have gone to the Supreme,
Charges, Supreme Court dismissed the SL.
the Supreme Court dismissed the SL.
Hello.
Yes, Ms. Jenny. LCR not received, counter affidavit not filed.
Your Lordship, in fact, on the previous occasion, the respondent had submitted before this court that they won't be filing their written statement, written
Okay.
submission.
So only thing is, why is the LCR required?
Yes, even otherwise,
You can, because it's a question whether
the
the
additional,
provisions of the law, the additional documents, you're not praying for additional documents, madam. You are praying that these were documents which ought to have come in, but they were lost.
they were lost, and therefore,
Then it came in, subsequently it was there. So I want to,
adduce
Bring
that
it
in, as,
they object, saying that there ought to have been a reference at least,
exactly, Your
which is not there.
my, if your Lordship
If it is order 10, I suppose, additional,
ordered,
that is a different aspect altogether.
Yes.
You are, this is not a case
yes.
under that. You get my point? So explain that.
I'll just, prior
Any
to that,
decision.
prior to that, Your Lordship, I'll just place the, because, Your Lordship, there is with regard to jurisdiction also, that the jurisdiction of court, when it has, when it was established before in our.
Madam, that is not an issue here. Here the issue is different.
I'll just come to that fact, Your Lordship. If Your Lordship will see my petition that was filed,
Hmm.
the money suit, Your Lordship.
No, just clarify one thing.
Yes.
In your, these documents that you, around 450 pages.
Yes.
Now,
Yes,
now, these documents, is there any reference in your plane?
yes, I have in my place.
These documents have been referred to in the plane.
Yes, Your Lordship.
Show me that.
If Your Lordship will come to page number 22, Your Lordship.
Hmm.
Here's the initial plaint, Your Lordship.
Hmm.
Now, Your Lordship, if Your Lordship then turn to page number 26,
Hmm.
paragraph 4, Your Lordship. If I may read the first 3 lines, Your Lordship, that the plaintiff begs to state the cause of action has arose when the plaintiff deposited creditors his check in the account of the Young Large Corporation Society since from date on 16/6/2015 to 30/11/2016, Your Lordship. The cause of action arose on this particular years, Your Lordship. Now, if Your Lordship then turns.
Because they had filed an application saying that you don't have a cause of action.
Yes, that was also decided by this honorable court on the earlier round of litigation. Now, if Your Lordship will see at page number 27, Your Lordship, paragraph 5, that the plaintiff begs to state that with effect from 16/6/2015 to till 1/11/2016, various checks have been deposited in the account of the defendant, wherein the 7% is deducting by the defendant number 1 and 3% is deducted by respondent number 2 till 31/3/2016, and thereafter from 1/4/2016 to 30/11/2016, Your Lordship.
Hmm.
Now, again at page number 28, Your Lordship.
Para 10.
Your Lordship. I had also craved leave of the honorable.
That is for additional documents.
Yes, that is the initial document. I have craved.
Here,
for.
this is not a case for additional documents.
Yes. Now, if Your Lordship will see my application when where I had taken the leave of the court, Your Lordship, which Your Lordship will find at page number 109, Your Lordship.
Hmm.
At page number 109, Your Lordship will see while making a reference, Your Lordship.
Hmm.
My at page number 111, my prayer was for checks and letters of LOC copies of counterfoils of the bank deposits, copies of statements of account of the plaintiff, as well as copies of detailed account statement of the dependent. Now, if your lordship will see D, along Tuting, Monigaon, and Metroka with effect from 18/7/2015 to 24/4/2016. There is no extra document beyond whatever year I have given.
This is for establishing a cause of action against respondent number 3 and 4, defendant
Yes.
number 3 and 4.
Yes. Now, even
Yes,
my
you are appearing for? 2 and 3.
even your lordship, my document consists nothing of extra document which is out of the cause of action that was reflected in the plaint, your lordship.
Now, why was this, that these documents were missing, not being traced out?
Yes,
Not even averred in the plaint?
it was as per the annexures, your lordship. There is a diary annex along with my plaint, your lordship. There is a where there was a reflection of my noting as to when was the deposits
No,
made.
where is
Your
that corresponding statement?
lordship,
You have now taken up the
I-
plea.
your lordship, I have not taken.
The apprehension may be that you deliberately did not give this. And now you want to improve your case because of the IF filed by the respondents, defendants.
The IAM is mainly for deleting the name, lordship,
With an estimate.
which we will contest as per if required, your lordship. However, my submission is that when a cause of action, because I cannot write down the check number as well as the
So you could have made a statement.
yes, my statement, therefore, I'm relying is that when my cause of action, I have specifically stated that credited, deposited of checks in account of so-and-so, Jang Corporation from the date so-and-so 16/6/2015 to 30/11/2006. There is no specification as to the number of check and the deposit slips number, but there is a specific statement made in my plaint, your lordship. Now, if I may take, I'll just place only 3 judgments, your lordship, with it, if I can.
This is on the point.
On the point with regard to if the cause of action reflects my claims, your lordship. This is of our own High Court, your lordship. I would like to rely from paragraph 6, 7, and 9, your lordship. If I may read, your lordship. Order 7, Rule 14 CPC provides for filing of documents relying on plaint. Order 7, Rules 14(1) provides that if the plaintiff sues or relies upon a document in his position of power, he is required to produce or annex such documents in the court when he presents the plaint by delivering a copy thereof along with the plaint. Order 7, Rule 14(3), which is our case, your lordship, further provides that if the plaintiff relies on any documents which ought to have been produced in the court when the plaint was presented by him by delivering a copy thereof, the same could not be produced at a later stage of the suit with leave of the court, provided such documents are produced for cross-examination of the witness of the other party or handed over to the witness merely to refresh his memory under Order 13, Rule 4. A bare reading of Order 7, Rule 14(1), it is seen that if the plaintiff sues upon a document in his...
See, this is subsequently you can produce it only for a specific purpose.
Purposes, your lordship.
Cross-examination and also for refreshing.
Exactly, your
It
lordship.
cannot be relied upon as for the purpose of cause of action.
Absolutely. And therefore, I was saying that if my additional documents is even considered today, your lordship, that is upon the discretion of the court not to take only to rely this on cross-examination, but then not allowing me to adduce
So,
this evidence.
so that may not be.
Now,
the-
I will just then proceed to paragraph 9, Your Lordship.
Mm.
In the case at hand, it appears that the document which has been sought to be relied upon by the plaintiff at this stage has been filed along with the application prayer for necessary leave of the court, and the court has granted a leave while impugn order. In such circumstances, it cannot be said that mandatory provision of law has been violated by the learned trial judge in passing the impugn order, in as much as the basic claim of the plaintiff is non-payment of necessary bill raised by the plaintiff towards treatment of various employees of his defendant petitioner. That being the basic claim of the petitioner, as can be found out from the paragraph 6 of the plaint, the contention of so and so that no foundation has been laid by the plaintiff has no force. Even my contention is, Your Lordship.
You mean to say that your foundation is that statement?
Statement, Your
With
Lordship.
regard to deposit of checks.
Checks and
in the
deposit,
account of the customer.
along with the annexures that has been relied in my plaint, Your Lordship. Now, if Your Lordship will see that the trial, the reason for giving the list of date is that Your Lordship has already gone through the petition, Your Lordship, that
What are the other
Why-
decisions you want to rely?
two decision of the apex court with regard to that, the liberty to given to the parties to adduce evidence if the process of cross-examination has not yet
That
started.
same thing.
Yes, otherwise also I'll just, this is a base.
Can just give me those. Yes, what is your case?
It's not medicable, my lord. Because, my lord, pleadings, my lord, which has been put forward in a plaint, those cannot be treated as an evidence, my lord. Evidence documents, my lord.
It's different.
So, my lord, the pleadings which they have pleaded in the plaint, it cannot be. He might have cited the documents, my lord. Where is this documents? The whereabout of the documents should have been, my lord, pleaded in the plaint,
Statement.
my lord. Then, my lord, it can be allowed in the later stage.
Hmm.
So, my lord, that what's order 7, rule 14 says, my lord. My lord, my lord, will see this order 7, rule 17, my lord. It comes, my lord.
CPC. Order 7?
Rule 14.
These are the same point, Mr. Zini. Ms. Zini. On the same point, my Lord Justice H.N. Sharma's judgment, this
Yes.
is also on the same lines.
But then only the point with regard to that is, if in any manner whatsoever the reason is, Lordship, the apex court has stated that since the cross-examination has not yet started, it would be prejudice on the part of the court for not allowing for reducing of the additional
Okay,
documents.
we'll consider.
The stage of-
Order 7, Rule 14.
This application was filed under rule 3, my lord. Prior to that, my lord will find rule 1 and 2. my lord. One says, my lord, this ought to have been filed. Second says, whether in the positions of the plaintiff, it was or it wasn't. Then, my lord will see the third. If it wasn't, then a leave of the court has to be obtained. So close.
And she has filed that application.
It is rule 3. So, my lord, rule 3 comes with a panel. my lord. But rule 1 and 2 has to be complied. my lord. If not,
So, on a document or relies upon a document as well, power. And so he shall enter such document and shall produce it for the plaintiff's possession, and shall the thing. And so, where any such document is not in the possession of or power of the plaintiff, he shall, wherever possible, state in those possession, which ought to be produced when the plaintiff is present or in influence and also and shall not without leave of the court be received in evidence on his behalf at the hearing. So, nothing in this rule shall apply to document produced for the cross-examination of the plaintiff or handed over to a witness merely to witness. Okay.
subsequent to this, my lord, order 13 comes, my lord, which says, my lord, original documents of the annex and the those were annexed in the plaint in the WS, it has to be submitted for the purpose of exhibition, my lord, to the course of trial. So, my lord, if this application is being allowed in this stage, my lord, it will be amount to the, my lord, amendment of the plaints, my lord. This is
Because,
principle.
Ms. Jenny, finally you will have to, you are bringing this on record to exhibit it as a witness, as
Yes.
an evidence.
Yes, Your Lordship.
You want to
Very-
exhibit these documents.
Yes, Your Lordship.
Otherwise, it's not just for the purpose of cross-examination or for the purpose of refreshing somebody's memory, witness's memory. You want to bring this as evidence. You want to make it exhibits. That is why you have taken recourse to.
That would be a part of the trial because, Your Lordship, if the learned trial, while allowing this and does not exhibit these documents, but then only for refresher
No,
of
no.
this.
That is a different stage altogether.
Yes,
But moment your application under 714 is allowed, you are permitted to bring these documents as exhibits.
not exhibits, Your Lordship. It will be a part of the record, Your Lordship. However, during the documentation, Your Lordship, this is the discretion of the court if the court exhibits it or not.
It becomes a pool. Now it is not there. It becomes a pool. It will be in the pool then.
Of-
You undertake that you will not exhibit these documents. We'll allow your
It will be
application.
not.
Can you?
I'll just come
No,
to
can-
that, but no, Your Lordship. I'll just come this.
There was another matter, similar matter. I think we disposed it off in that direction only.
Yes, Your
Madam,
Lordship.
may-
Now, my just a small contention, Your Lordship. As I have specifically stated, Your Lordship, even the documents that I relied on my initial plaint, Your Lordship, that also consist of the check numbers which has been annexed in this additional document, Your Lordship. That is
No,
also a part of.
The question here, the only it boils down to, why was there not, see your pleadings in a writ petition is evidence,
Yes, Your Lordship.
but your pleadings in a plaint is not evidence.
Absolutely, Your Lordship.
So there you ought to have made a statement as to why you were prevented from bringing, because those were the documents you are relying.
Yes, Your Lordship.
So you did not have it bona fide.
Yes, Your Lordship.
You had lost it, but there ought to have been a statement somewhere that this is the then this whole problem would not have arisen.
My contention is, Your Lordship, when my plaint,
This is a development you have made once he had filed that application.
that application is only for deletion of their name, Your Lordship, but the course of action.
Because
was
they
also-
say that there is no cause of action against me.
That was also decided by this honorable court, Your Lordship, on first round of litigation. That, Your Lordship,
Then
As per-
court, what did this court say?
this court has partially accepted that there is a cause of action because they have filed on the initial time, they have filed an application for deleting their name on the same ground, Your Lordship. This court, if I may take Your Lordship to that order, Your Lordship.
My Lord Justice made his order.
No, not Your Lordship. Initial order. It was passed in 2017, Your Lordship, at page number 73, Your Lordship. No, Your Lordship, page number 76, Your Lordship.
That's it. 73 is the trial court's order.
Yes,
My Lord Justice Bhotta, sorry.
yes. If I may just read only para 2, Your Lordship. By preferring this revision under section 115 of Code of Civil Procedure, the petitioner now, if I may take Your Lordship to page number 86, Your Lordship, where is the conclusion of the
Para 15.
para 15, Your Lordship.
Anything more, Mr.?
Yes.
Hmm.
Page number 111.
111.
Find this documents A, B, C, D. These were the documents which petitioner wrote. These documents, see this document number C and D. C is the copies or statement of accounts of the plaintiff against account number 7. And follow D is the documents which has been unilaterally prepared by the plaintiff. Follow the vision of these two documents, my lord. It is the documents of the plaintiff himself. This cannot be, my lord, subject matter of misplacement. It could have been able at any stage of time, because it is a state account statement of the plaintiff. So, my lord, in this case, this suit was filed in the year 2016. Only in the year 2024, my lord, this I was filed. So, my lord, these documents.
That is a plea that you had taken before in your objections.
Well, we have not filed.
No. Somewhere I found maybe after 6 years, maybe in your
Yes,
arguments
yes.
before the trial.
Yes. There is.
Okay.
Your Lordship,
So, my lord, I have
one
not
small submission, Your Lordship.
authority, my lord.
Even taking into consideration that
Just write your name on the top.
if at all from all these,
It's
Write
already
this.
written.
if at all from all these 4 documents that I had taken leave for reducing the additional
Visual.
documents, Your Lordship, the order of the Honorable Trial Court not taking into consideration Order 714(3), but Order 7 Rule 4.1, Your Lordship. He was basically on Order 741, Your Lordship.
In
If
the
Your
order,
Lordship- Yes, if Your Lordship will come to page number 631, Your Lordship.
internal page,
631, Your Lordship.
internal page of that, internal page.
The
there is a
four-
internal page,
four-
page 4.
4, yes.
Hmm.
If I may read the 3rd para, Your Lordship. The
Wow.
perusal of the
Plain.
perusal of the plain that the petitioner has not given the list of the documents which he now intend to adduce. Order 1714(1) does not speak about. Order 17 Rule 4.1 speaks about giving a list when a plaint is filed, Your Lordship. Order 7 Rule 14.3 gives put an exception to that and gives the liberty to the parties to take leave of the court, file a leave application, Your Lord. So even on this ground that he has not submitted a list of documents before reducing evidence at this stage also does not in
Sure.
any manner.
Okay. Anything more? Anything more?
Only I would rely upon the judgment of the
That you
apex
have
court.
already
Your
given me.
Lordship. Yes.
But the learned counsel for the parties at length registered to discuss matter again. Goodbye, next Wednesday for delivery of orders.
Deeply.
I'll have to read it.
Yes, sir. Deeply.
Give this file to me on Friday. Item number? Slip by slip.
Lord, this is criminal petition, my lord.
Yes, Mr. Ade, the informant is no longer there, he has deceased.
Yes, Your Lordship.
But he has, before the trial court, categorically stated that this was not done by me and he had never come to.
Yes, Your Lordship.
What would be the effect?
Your Lordship, Your Lordship.
I forget the wives.
Yes,
that is
that cannot be
the-
taken into consideration. But Your Lordship, the issue here is the prima facie, so far as FIR is concerned, the offence has been committed, cognizable offence. So till the charge sheet, when charge sheet is filed also, it clearly disclosed the commission of the offence. After commencement of the trial, my lord, the informant has perhaps turned hostile or he has he stated something. So whether at this stage, Your Lordship, the statement given during the trial court in the evidence will have bearing on the FIR that which has been recorded long time.
What happened to the approver? Has the approver stood his ground?
Your Lordship, the TCR is there, Your Lordship.
Just go through it.
Yes.
This year is there. What happened to the approver? Approver has stood his ground. There was an approver.
No, my lord.
And
My lord, so far,
Give it to me.
PWs has been, my lord, examined by the court, my lord, trial court, my lord. And they are prominent witness in this case, my lord.
both of them has, my lord, denied that the petitioner has ever come to the scope of the complaint.
But that is not the stand all along.
And my lord, in the charge sheet, your lordship will find the arms act also, your lordship.
No, otherwise a serious offense.
Yes, your lordship. The only, my lord, the concern here is, your lordship, if suppose, your lordship, no doubt in 482, your lordship, the 520 is corresponding section, that can be exercised at any stage. But considering the fact and circumstances of the case, your lordship, there is a judgment, your lordship, of the Honorable Supreme Court, when it has been held that even when the trial commences, it can be exercised. But your lordship, on the fact that the FIR does not disclose commission of any offense, on that case, your lordship.
But here the FIR
Here-
as well as the charge sheet
Yes.
discloses.
Yes, your lordship. And trial commence, your lordship. So now, once trial commence, your lordship.
We'll have to be a bit more
Yes, your lordship.
careful.
Because, your lordship, if nothing is there, he will be acquitted, your lordship.
Yes.
My lord, I'm sure, my lord, I have seen the statement of the, my lord, PW's, my lord. I am also sure, my lord, I will be acquitted, my lord.
Then,
In
yeah.
this trial,
Then-
my lord.
Then,
But the only problem, my lord, is that, my lord, and for this filing application under for quashing, my lord, it is for the, my lord, end of the justice and for, my lord, in fact, to save the precise time of the trial court, even, my lord. My lord has seen, my lord, there is remote chance of conviction, my lord. In such circumstances, my lord, it will be, my lord, for the benefit of both the party, for the court as well, my lord, that such cases will be quashed by this honorable court, my lord. In fact, my lord, I have no doubt, I will be acquitted by the trial court, my lord.
then what is more
Yes.
left here?
What is difficulty?
But the, my lord,
One line order. One line order.
so my lord has seen,
You complete the trial.
my lord has seen, my lord.
There is
how,
more than
my
one
lord,
accused.
how this,
Locum, there is one more accused, there is a different case. That one more accused was there
no, my lord, he,
who had bought arms for you.
or there, my lord, in fact, it was my lord,
You are Locum Talo.
yes, my lord.
Yulam Achum.
Yes, my lord.
He is also an accused in this case.
No, my lord. He
He-
is with my lord, this discharge, my lord.
Oh, he has been discharged.
Yes, my lord.
And this is not only the case, your lordship, which was pending against this present accused.
There are others.
Yes, your lordship.
My lord, that, my lord, all those cases, my lord, is connected with the election of this, my lord, Eternal Market Welfare Society, my lord. The present petition, my lord. There was a election of this society in the year 2006, my lord. The present petitioner, my lord, he himself was one of the, my lord, aspirant for the post of president, my lord. So since, my lord, there are three candidates, my lord. They had a conspiracy, my lord. That is why, my lord, the statement of the, my lord, complainant, my lord, has to be, my lord, given priority, my lord. Because, my lord, since they do not
How
want.
many witnesses are more there to be examined?
My lord, there are 4 more witnesses, believe, my lord.
4 more.
Yes.
Yes, my lord.
Lordship, because your lordship, what is difficult, because your lordship tried to find out many judgment on this aspect, your lordship. After commencement of trial, your lordship, it will be either acquittal or the conviction, your lordship. And the Supreme Court, in your lordship, reiterate in many cases, your lordship, in many occasions, that if FIR, it is on the FIR and the charge sheet. And once nothing more, your lordship. Otherwise, your lordship.
See, we can't take into consideration your
Evidence.
Statement.
Yes, sir.
Evidence. It's beyond. When it's for quashing, it has to be the charge sheet per se. Nothing more. And charge sheet per se, if I peruse, I'm not satisfied that you are entitled to an acquittal.
My lord, how this FIR has kept to be filed, my lord?
That is in the trial. You establish it in the trial.
That, my lord, even, my lord, the complainant, my lord, the statement of the complainant, my lord.
No, statement of the complainant is subsequent.
No,
We'll not go into that.
Not only him, my lord, there is another witness, my lord, who is also deposed his statement, and he even said that, my lord, he did not see anyone.
That is something which the trial court will take into account. I'll stay just before the trial.
My lord.
I'll look into till before the trial. That is the charge sheet, not beyond that. What do you want?
My lord, let me bring in some other pains, my lord.
Hmm?
This is third time, man.
That time is like my.
Third time.
Third time he's trying, he want to try his luck.
Straight for by Mr. So learned counsel for the petition and not objected to by Mr. Ete, learned additional public prosecutor, raised to list this matter again on Monday.
My lord, let it be some after 2 weeks, my lord.
You want me out of
No, ma'am. Much of
after 6 weeks on a date to be fixed by the registry.
My lord, let it
Now
be.
you continue with the trial.
My lord, after 3 weeks then.
No, 6 weeks. You have complete satisfaction, then come back. Okay.
Much obliged, my lord.
Obliged.
Yes, Mr. Kato. Want to make any submissions here or it's covered by
Yes,
Mr.
my lord.
Justice
Already.
Bulwar's order?
So many other cases, same line of this.
Hmm. So we'll follow that. Watch this.
Yes.
Monday.
Deeply obliged.
Monday.
Deeply obliged.
Heard, hearing concluded Monday, huh? I'll just quote from that. And that same very notification, which is your problem here,
Yes.
has already been interfered.
Yes.
That has not gone up on appeal, no?
That judgment, it has been declared ultra virus.
Hmm.
Deeply obliged.
Yes, my lord. Who is there for you, the opposite side?
Mr. Tama,
Where is Mr. Tama?
there is a caveat, my lord.
You are appearing for the caveat.
My lord, this is a appeal, against my lord, under order 43 rule 1, read with section 151 of the CPC, my lord, against the, my lord, temporary injunction.
He has gone deep into the matter.
Not only that, my lord,
The 3 golden principles have been very nicely looked into.
but my lord will see, my lord, the nature of the case. my
Now forget the nature.
lord.
If this order is not passed, the whole thing will fall through.
My lord, then here is the case. My lord. After 9 months of the declaration of the result, if somebody approaches, my lord, challenging that election result, then, my lord, the law, my lord, as far as the law is concerned, my lord, apart from this, my lord, 3 principle, my lord, another issue is, my lord,
You
conduct.
have that results have not led to your holding that post. Before that, this has come.
My lord.
The results did not result. Consequential, that effect of that result were not given. It was pending. Then this came.
Yes,
Right?
Yes.
You had not sat in that chair.
my lord.
Before you could sit in the chair, the restraint order came.
Oath was, my lord, there is a, my lord, one title suit is there.
That's what I'm
That
saying.
is what happened. But before that, my lord, it is pending because that injunction order has been issued without hearing the party.
Then this IA was filed, you were heard.
My lord.
So if after you say 9 months,
That
after
is
9
one part. Apart from that, now, my lord, nature of the case, if you understand. Whether this prima facie case balance of India, whether this has been fulfilled or not.
That we'll hear you.
Yes, ma'am, on that principle.
That we'll hear you,
Yes.
but not today. We'll hear it. Because I've gone through it.
My lord.
It has been done. For your satisfaction, if you want, we'll give you a date for hearing. We'll hear the matter. Yes, Mr.
Here,
Raman.
my lord, we can hear and dispose it. One short date, my lord. I'll
Yes.
say, my lord.
I'm not satisfied to stay this order. I'm not inclined to stay this order. Heard Mr. R. Sona, learned counsel for the petition. Also heard Mr. Tama, learned counsel, representing all the respondents.
Yes, my lord. Not pro forma. They
You
have
are,
made some proper dependent also.
you are representing 1 and 2.
1 and 2, my lord.
And what about 3 to 6?
My lord, I'll take the step.
You'll sit. Tama represents, appearing for respond number 1 and 2. Full stop. Issue notice returnable 4 weeks. Petitioner, Mr. Tama accepts notice on behalf of respondent number 1 and 2. Accordingly, no formal notice is required to be sent. Full stop. Petitioner to take steps for service of notice upon respondent number 3, 4, 5, and 6 by way of registered post with AD as well as by way of usual process. Steps within 3 working days from today. Full stop. Registry to list these matters after 4 weeks.
My lord, may I pray for fixed date, my lord?
Give me a date.
18 June, my lord.
Will it be 4 weeks?
My lord, before date, my lord, because this is a continuation appeal, my lord. I will serve the copy to the, my lord, council.
Dusty.
Yes, my lord, I can, my lord, do it through the council also. This is the continuation of the.
But that they may accept, they may not accept. Then you
Dusty maybe.
petitioner issue notice, huh? By way of registered post issue. Petitioner is also permitted to take steps upon the said respondents by way of Dusty routed through the registry of this court. Also, petitioner to file an affidavit after effecting service by Dusty mode. Also, registry to list this matter 3 weeks question, 4 weeks question, registry to list this matter again on 18/6. 18/6.
Not 18, my lord. Kindly 25th, my lord.
25th,
My lord, I have difficulty, my lord. Maybe 27.
27,
My lord, oh, fine.
6, 2024.
Much over.
Highly honored.
18.
I do not think, no. We both are eagerly waiting for the items to come.
I'm also eagerly waiting. Now the question is whether the chicken came first or the egg came first.
But the issue is very limited.
No. Why? Whether the leave application was first granted or the delay is to be first controlled. The delay, this leave has to be granted.
Correct, madam.
Now the grant of leave is not under challenge.
Correct, madam. That is what I.
Admittedly, madam. Admittedly, madam. At that relevant point of time.
So this challenge is honest.
So therefore, madam, may I pray that, madam, in that case, madam, I may be given liberty to, madam, file appropriate applications for that, madam, impugn order, madam.
That is up to you.
Madam.
But this petition is not maintained.
Correct.
Madam.
Even, you know, the main.
Madam, admittedly, madam. Fairly, madam, I concede myself, madam. That
Thanks to Itanagar bench,
madam.
I have picked up something about the civil and the criminal side.
Madam.
A little. Jimmy is laughing.
Madam.
Thanks to this bench. Really. It's because of you people.
Well, I was telling my brother Kato that your application is not mentionable on the ground that leave.
The
Granting
leave
of the leave was not challenged.
gives the jurisdiction.
Madam,
Correct.
exactly, madam.
Right?
Therefore, 21.
Condonation is just a formality.
Formality.
If the leave stands, this thing will not be maintained.
Madam, what happened? Leave was granted long days back, madam.
What do you want to do?
Sir, madam,
Withdraw.
May I pray that, my lord, I may be given liberty to, madam, to file a prayer.
No liberty.
That much only, madam.
Had it been
Will-
a young council member, I could have considered for liberty.
My lord.
Definitely,
that
of this
option-
not
Madam,
nature.
that option is, madam, always open.
See, the problem here is you have touched on the question of leave
Madam,
in your petition, but while you drafted your prayer, you omitted that.
madam, in fact, yes, admittedly, that has not been, madam, challenged. We have touched, madam, that somewhere it has been specifically mentioned, the leave was wrongly granted. Even.
No, it's.
Madam, para 7,
No, there is a touch. He has touched on the leave thing, but he has not
challenged,
prayed, not challenged it.
nor in the prayer.
No, not in the
no,
prayer.
admittedly, madam, that I consider it. The proceedings BC said
stated, my lord, and from the that, my lord, the granting of leave, man.
Where is that impugned order?
My lord, the impugned order is page number
It's here, it's here.
annexure 10, my lord,
164.
165.
21 days leave. We are dismissing this. But if I dismiss this,
But
everything.
wrongly calculated, my lord. As if it is calculated from the date of order, my lord, as per the, my lord, the Limitation Act, it has to be counted from the date of the decree, my lord. Then it comes, my lord, more than 51 days, my lord.
No, they may not know about the Keba order. They were
That-
not there. The leave has been sought for because they are not a party to that.
My lord, that is the
Right,
crux of the case, my lord. They were present, very much present at the time of.
That
my
is
lord.
merit. That is merit. That merit will take
And
care.
he, and both the matter, subject, interestingly, my lord, subject matter of the complaint is different, my lord. The adjudication, my lord, which has been made, arrived at, my lord, decision arrived at is something, my lord, different. So therefore, my lord, without touching the original, my lord, the decision passed long year back, my lord, there has not been.
This is a discretion of the court. Delay condonation is discretion of the court. The court has exercised this discretion, fine.
Admittedly, my lord, the mistakes on the part of the petitioner is, my lord, he has not challenged the, my lord, the leave order, my lord.
Can't help it.
You take preliminary objection.
Hmm?
You can take preliminary objection before the trial court.
But in this case, my lord,
We are upholding this order. Then your thing will be dismissed. Heard Mr. M. Kato, Learned Counsel for the petitioner. Also heard Mr. T. Tara, Learned Counsel, appearing for the all the respondents. For the respondents. So the challenge in the present order is to the challenge in the present revision petition is to an order dated 11/2/2025 passed by the Civil Judge Senior Division bracket of allow Civil Judge bracket Senior Division bracket over allow in this case number 22/2024 in Civil Appeal number 04/2024. So the respondents herein had instituted the said civil appeal and had also preferred an application being miscase number 22/2024 praying for condonation of 21 delays in filing the corrected appeal. So the learned trial court on consideration of the matter and on drawing satisfaction that the appeal in question was filed within the limitation period as the limitation in the matter would run from the date when the order of the Keba was received by them. So, accordingly, basing on the said conclusion, the learned trial court proceeded to allow the application seeking condonation of delay and had directed that the connected civil appeal, being civil appeal number 4/2024, shall proceed further in accordance with law. So I have perused the application as filed by the respondents before the learned trial court, and I'm of the considered view that sufficient cause has been set out therein, and the learned trial court had rightly exercised its discretion in condoning the delay involved in filing the connected civil appeal. So the appellant, the petitioner in the present petition has failed to bring on record any material which would demonstrate that the discretion exercised by the learned trial court was exercised without there being any cogent material on record. So Mr. Tara has some in view of the above position, this court is of the view that no error exists in the order dated 11/2/2025, and accordingly, the same would not mandate an interference. So, in view of the above discussions, the present criminal revision petition stands dismissed.
This is small observation regarding the
Interim order.
Interim order, if any, shall stand vacated. Mr. Suna, you are in both the cases?
Yes, my lord.
In the second case, you have not taken steps.
Second, but my lord.
Your Lordship, I have submission to make. Here's the notification, recent notification dated 3rd May 2025.
What does it say?
First point, if bail applications are assigned to different single judges, benches, in that event, all the applications arising out of same affair will be placed.
So, okay, what do you want to say? If there is any other court examining this matter?
Initially, my lord, this matter was withdrawn once.
Then point 3, cell number 3. In case of subsequent bail application prepared by the same accused in the same affair, that is bail applications prepared after rejection of earlier bail application, such bail applications shall only be listed before the same honorable bench who had earlier decided, within bracket, either on merit or dismiss as
Mr. G. Tado, learned,
Yes.
additional public prosecutor has drawn the attention of this court to the notification number 27 dated 3/5/2025, more particularly to clause 3 thereof. So it is submitted that the present applicant had earlier approached this court by way of instituting bail application being BA number 65 of 2024, which was dismissed on withdrawal, which was disposed of by a coordinate bench of this court, white order dated 23/12/2024. So in view of the above position, the registry to examine the matter in the light of the provisions of clause 3 of the said notification number 27 and list the matter accordingly. Both.
Yes.
cases.
Arising out of same
Same
affair.
affair.
Mobilized Lord.
Next one also.
May I please, Lordship? My lord, this petitioner was arrested on, my lord, 21/3/2025, my lord, regarding an affair, my lord. Kindly turn to page 16.
Prior to that, Your Lordship, this matter has already been charge sheeted. On the previous occasion, CD was called for, Your Lordship, but then
Which charge sheeted now?
even prior to this petition was filed, it was already charge sheeted. So scan copy of the trial court record.
Ms. T. Ginny Leonard, additional public prosecutor, appearing for the state respondent, submits that the charge sheet in the matter has already been filed. Also, in view of the above position, registry to requisition a scanned copy of the charge sheet filed by the investigating agency from the trial court. Full stop. Registry, how long does it take?
Your Lordship, you may just give a week's time, Your Lordship.
Registry to list this matter after a week along with the scanned copy of the trial court.
My lord, kindly one thing, my lord, this petitioner was, my lord, 3 or 4 times, my lord, was admitted in the hospital. He is suffering from hepatitis B, my lord. So, my lord, one direction may be given to proper treatment.
It is submitted that the petitioner is suffering from hepatitis B and is in need of treatment. Full stop. The jail authorities shall ensure that the petitioner receives adequate treatment, due and proper treatment for the ailment suffered by him. On the next date of listing, Ms. Ginny shall receive instructions with regard to the treatments provided to the petitioner by the jail authorities for the ailment suffered by him and place the same before this court.
Your Lordship, a copy of this order may be given to me.
Download it.
Please.
It will be uploaded today.
Deeply applied.
Highly obliged.
So, my lord, this AB is in connection with the DTBR based.
His statement has been recorded.
Yes, Lordship.
Huh?
Yes, Lordship.
So, my lord,
And what happened to the other one? Abdul Hussain? There were 2 persons.
This is for Jalil Haq, Lordship.
There was another bail application filed for another accused,
Madam.
Abdul Haq.
But I am confining with the my lordship.
No, what happened to that?
Lordship, here Lordship in the case diary,
Hmm.
the bail application received from one Abdul Ahmed for the receipt of bail, but other one Lordship is already, I think it's, they have granted bail Lordship in this.
No, that is, anticipatory bail was granted.
Yes, yes, Lordship.
That was made final,
No,
absolute.
Abdul Hussain Lordship.
Hmm. Final.
It is Lordship, yes, Lordship, in the page 19 Lordship.
Hmm. That is the interim order.
Yes, Lordship.
Now, what happened here? Has he recorded his statement?
Yes, Lordship, his statement is being recorded.
Ah.
And now for keeping the case for pending the further investigation on it.
So what do you say? We allow him to?
Lordship, as per the Lordship, this is for detention Lordship, they are not objecting as well, Lordship.
Hmm. No,
Yes,
custodial
Lordship.
interrogation is not.
Yes, Lordship.
So make it absolute.
Heard Mr. C. Modi, learned counsel for the petitioner, as well as Ms. L. Hage, learned public prosecutor, appearing for the state. In terms of the order passed by this court on 9/5/2025, granting interim bail to the petitioner, it is submitted that the petitioner had appeared before the investigating officer and his statement has been recorded. It is submitted that the petitioner is cooperating with the investigation of the matter, and accordingly, further custodial interrogation of the petitioner at this stage is not called for. So, in view of the above, the interim bail granted to the petitioner while the order dated 9/5/2025 is made absolute with the following conditions. ये लगा देना into the petitioner एक खाली उसमें ऐड कर देना 3 को काट दीजिएगा. The petitioner shall appear before the officer before the investigating officer as and when called for the purpose of investigation of the matter. 1, 2 और ये वाला 3 होगा आपका.
All right.
With the above observation direction, bail application stands disposed of. Disposed of.
Well, I have been appointed as a amicus curiae in this matter, and I have received recently received the paper book. So this may be listed after 1 week, man.
We'll have it for admissions then. It's not been admitted. Delay condoned.
Delay, already condoned. Even a paper book was preferred. So matter may fix for hearing.
No, it is not been admitted. Has it been admitted? No.
Yes.
Heard Mr. O. Modi, learning counsel for the appellant. Also heard Mr. G. Tado, learned additional public prosecutor appearing for the state respondent, and Mr. C. Modi, learned counsel appearing for the amicus curiae, appearing for the respondent number 2. Admit the AP. Full stop. Paper book has been prepared and a copy thereof has been heard on all the learned counsel, on the learned counsels for the parties. Full stop. Accordingly, the registry to list this matter for hearing when?
After 2 weeks.
After 2 weeks.
And my lord, praying for 198 matter, my name may be reflected in the.
The name of Mr. C. Modi, amicus curiae, appearing for the respondent number 2, be reflected in the cause list on the next date of listing. Who is appearing for the petitioner? Mr. Dhammo. Who is appearing for the petitioner?
I am respondent.
None appears for the petitioner on call. Your respond number?
Only sole respondent.
However, the learned counsel for the sole respondent is present. For the ends of justice, the registry to list this matter again after 2 weeks on a date to be fixed by. Panel witness.
We have.
Yes. You want to quash it?
Yes,
Okay, tell me.
my lord,
Under which power of which portion of 482 can I draw my power? To close a clear case which affects the public at large.
Your Honor.
It's a case of counterfeit currency.
On the last occasion, city was called for.
What? Forget her. You satisfy me that the informant and you executing an agreement,
Yes.
the case can be quashed. Such serious nature. Yes, Ms. Hage, can it be?
No, this is
Then-
not a private nature lawsuit.
No, this is serious. So we are dismissing it. Anything more to say?
Your Honor, as the informant also is.
Informant is nothing here, honest. Who is he? He has brought the criminal thing into motion, that's enough. This is not a private dispute. This is a dispute affecting the public at large. Distribution of counterfeit currency. You can't. So, anything more? Anything more, madam? No. Dismissed.
Offline.
I'm good with that. You'll get the order day after tomorrow.
Lordship, can see the case diary, Lordship can have Lordship.
This is not a case where I should
Yes, sir.
exercise my discretion under 480. That's it. There,
It's a
then-
public Lordship, it's a.
Oh, It's a. Against
Like-
public interest.
May I please, your Lordship?
Yes.
Yes, Lordship, in this matter, Lordship, basically challenging the appointment of respondent number 6, Lordship. The case is the nutshell is there.
6 is not here. Lordship.
Forget 6. Wait. How this has come to happen?
Lordship, I have.
There was a director, you have filed an affidavit
Yes, Lordship,
here.
yes.
When?
30.
Huh?
On 30, Lordship, on 30.
On 13/5/25.
Oh, I missed this affidavit. Okay. What is your stand here?
Lordship here, Lordship will. Lordship may come to the last page 42, my affidavit, Lordship.
Forty-two.
42. Lordship, first of all, the private respondent approached the authority first, and then here in this Lordship document, Lordship serial number 2. Formal contractual appointment order shall be issued from DC cum DPC after observing all further formalism. DC has been authorized, Lordship. He is a DPC in the district, Lordship. So there is no, Lordship.
No, where is the appointment of the respondent number 6?
Respondent number
Page
6 is
41, Lordship.
Page 41. Oh, it was appointment was done before this
Yes.
5-3.
Yes, Lordship.
Then
Then, Lordship, this document which is supposed to get right after I got an information that since the appointment which I was sought from, the direction was given from the higher authority, Lordship, has been already filled up, Lordship.
Already filled up means before the direction is of 5-3?
Yes, Lord.
Yes.
Lordship, in
And
that
the-
case, Lordship.
Huh?
So far as the Lordship, the guideline is concerned, Lordship, there is no specific guidelines provided by
So,
the department, Lordship.
all these appointments are to be made by the deputy commissioner.
Contractual appointment
it
on
has-
the basis, Lordship.
For that, Lordship, kindly come to the page number 26 of my petition, Lordship.
26.
Lordship. While monthly
Have
revising.
you seen?
Yes, Lordship.
26, huh?
Page number 26, Lordship.
Hmm.
The following terms and conditions have to be added by the implementing agency, Lordship. Clause 4, Lordship. Any appointment, Lordship, on contractual basis under MG Narega, the implementing agency should submit the proposal to the DPCOM ADPC, Lordship, DRDA to the state government along with the justification, Lordship.
Okay, now tell me. Come to back to page 42.
Lordship.
Is the director the government?
Lordship.
Is the director the government? You say in terms of 4,
Lordship.
proposal has to go to the government. Government will clear, then they will appoint.
Lordship.
Is the director the government?
In that case, Lordship, since the.
Government means secretary, the
So,
department.
yes, the law is
He is nothing.
secretary, Lordship.
So she is working from 26 to 2025, whereas your
Lordship, that
maybe this was not brought, and this post use is the same one.
Lordship.
Bomkar Pangman, computer assistant, retired.
Resign,
Resigned.
Lordship. After the resignation, Lordship, I have applied for the job, Lordship.
There is no selection here. It's just you applied, somebody gave you.
Yes, Lordship.
And she also applied, somebody gave her. Let her work. You better try next time somewhere else.
Lordship, the arbitrariness is in that, in
No
this case is that,
arbitrariness.
Lordship.
Nothing arbitrary here.
When we file an RTA, Lordship, seeking an information regarding the appointment of the respondent number 6, Lordship, they were flatly denied on my face, Lordship.
No.
Now, after the 1 month, they file an affidavit by bringing them on record this appointment order of the respondent number 6.
Madam has filed an affidavit. She received the instructions.
Yes, Lordship.
She filed it.
Page 40.
But for that
Yes.
also, they don't file affidavit, you have a complaint. They file an early affidavit, it becomes malified. That should not be. What to do? Dismiss.
Lordship, in that case, let them at least, respondent number 2, let them file the affidavit, Lordship. Since
No,
they
they have filed it. This is enough. This is enough. 4 has filed, that is enough. He is the main man. And madam will have naturally received instructions from respondent number 2 director also.
Yes.
Right?
Lordship, director, for director, he is there.
What is it?
Last time there was an understanding that.
Your hand always
Well, I-
wants to sign somewhere. So whatever comes, you sign. Huh? You don't see whether the post is there, filled up. If that respondent number 6 has been appointed, he has the scheme. Why was that appointment not undone before you issued this direction?
Actually, what happened on the last.
Or somebody comes and requests, okay, jao. Huh?
Like that,
Then-
well, actually, on the last occasion, there was an understanding that the affidavit of the defendant, respondent number 4 would be enough. So we have not filed our.
You did not file, but why this? Why have you issued this?
That I take instruction of. Because
Tomorrow.
Well, next week.
No. Today is
Because-
Tuesday.
because
When
it's
is it?
already-
Thursday.
Lordship.
Applies.
Leave, Lordship.
Nothing. For your satisfaction, I'm done.
Lordship.
Assignment. This is continuous application.
This is not done. What is the error? Okay, condone, I am condoning it. doing its condone. What is the error in the review?
Uh,
Review has to be, there has to be an error apparent on the face of the records.
my lord, yes, my lord, that if
Your case is that your junior forgot to make it. Is that an error?
my lord,
Then you go upon appeal. This cannot be.
yes, my lord, if, in addition to my lord, this error apparent in record, my lord, my will be some other reasonable ground, my lord.
No, no.
Citizen, my lord, will kindly appreciate, my lord.
And how can the review filed by a separate set of counsels? You were not a counsel in the original writ petition or the whatever the revision petition.
My lord.
You were not a counsel.
No, no.
How can you replace? How can that be replaced? If this is a ground, it has to be taken by them, not by you. How do you know that it was a mistake? You were not there.
No, my lord,
Then-
on the report, my lord, I'll try to.
That it's a presumption.
No, not on a presumption, my lord. My lord will kindly see, my lord, in the CRP, my lord, the order put on challenge, my lord, was the execution order, my lord. Execution order by the DC, my lord. Now,
See, the revision petition was withdrawn
yes, my lord.
so that they can institute an appeal before the civil judge senior division
My lord.
in terms of that amended
My lord.
provisions.
My lord.
What is the error there?
My lord.
Why should a liberty be granted?
My lord, kindly appreciate, my lord. In the appeal can be prepared against the
Kebang decision.
order of the past appellate authority, my lord. Not against
This appeal is against the Kebang.
Kebang, my lord.
Kebang decision, they wanted to file an appeal before the civil judge senior division.
Senior division, my lord.
What is the error?
No, my lord.
Is it not maintainable?
That was no, that appeal, my lord. That appellate order was not put on challenge in the CRP, my lord. CRP, my lord, the execution order, my lord, by the DC, my lord, was under challenge, my lord.
Decision, Mr. There may be 101 orders put upon appeal. But 24/2/2022 is the order of the Kebang authorities.
Yes, my lord, Kebang.
Against that, in terms of the present state status, an appeal is maintainable before the civil court.
My lord, against the, my lord,
against the Kebang decision.
appeal, my lord.
Civil judge junior division, civil judge senior division, or the district judge.
My lord. My lord.
As per pecuniary condition.
My lord.
They have sought for that.
Yes,
to file an appeal.
My lord.
What is the error?
Now, situation, my lord, suppose tomorrow, my lord, even if this appeal allow, my lord, appeal allow, my lord, there will be no remedy against the order, my lord.
You can come here under 227. We are here with you.
My humble understanding, my lord, suppose tomorrow appeal is allowed, my lord. Once, my lord.
That is a different thing. I am only, appeal is allowed. What happens, what does not happen, happens. But here,
my lord, in the CRP, my lord, that order, appellate order was not under challenge, my lord. The order under challenge were.
The prayer is for preferring an appeal against 24/2/2022. For that purpose, they wanted to withdraw the CRP. We permitted that. It's not for anything else but to prefer that appeal. Appeal, whatever happens, you have your remedy.
Yes, my lord.
Then, have you filed the appeal?
Yes, my lord.
Then,
appeal.
Wastage of time of the court.
No, my lord, kindly. Tomorrow, my lord, my situation here is, my lord. Tomorrow, suppose appeal.
Tomorrow, what happens, we'll see tomorrow. Today, I can't.
No, until, my lord, unless, my lord, this is review, my lord, no liberty is given, my lord. I would not be, there would be no.
Why should a liberty? If there is that's a fresh cause of action. If something happens in the appeal, you have a fresh cause of action.
No, my lord, the execution order still exists, my lord. Yes, my lord.
Because that execution order will merge with the appeal. You you have gone for an appeal.
No,
you can prefer
not against the execution order, my lord. Appeal was not against the.
I'm sorry.
Execution, my lord, kindly, my lord. Two different things, my lord. Once, my lord, appeal was prepared against the appellate order, my lord. Now, in the CRP, my lord, before this honorable court, my lord, the order only put on challenge was the execution order, my lord, not the affiliate order, my lord. Now, in such situation, my lord, if this is not review, no liberty is granted, my lord.
This court had granted you liberty to challenge the Kebang order, the original order.
My lord.
Then,
Surely, my lord, but in the CRP, my lord, will kindly see, my lord, the order put on challenge are only the execution order, my lord, not the Kebang order, my lord. Now, in such situation, my lord, if liberty is not granted, my lord, by the order which I am seeking review, my lord, the execution order, my lord, will attain its finality, my lord. Now, in such situation, my lord, though appeal may be allowed, my lord, ultimately, if no liberty is granted to put me on challenge the execution order, my lord, that will be final order, my lord. There cannot be any remedy, my lord, unless remedy is given, liberty is given to me, my lord. That's the only issue, my lord. Well, my situation, my lord, will kindly consider my situation, my lord. My situation is not that intent. I pursuing the matter.
had Mr. L. Prami, learned counsel for the IMM, learned counsel for the petitioner. The present interlocutory application has been instituted, praying for condonation of delay of 135 days in filing the connected review petition. Also, issue notice, returnable 4 weeks. Petitioner to take steps for service of notice upon the respondents number 1 and 2 by way of registered post with AD as well as usual process. Petitioner is also granted liberty to serve notice upon the respondent number 1 and 2 by way of dusty routed through the registry of this court. Full stop. In the event the notices are served by way of dusty mode, the petitioner to file an affidavit after effecting such service. Registry to list this matter again after 4 weeks.
Highland.
In this item number 30 may be taken first because item number 30, the consequence of item number 30 will bearing on the item number 29. Yes, 456 may be taken first. And consequence of this 456 will follow the.
How long will you take to argue?
My only ground is the violation of the natural justice law, OD alter partum. I was not given opportunity of being out before cancelling my land possession certificate, my lord. And the order, the interim order passed by the Lord Deputy Commissioner, my lord, is not this region order, my lord. My lord. Phase 18 is the interim order, my lord. Deed and Deputy Commissioner, one land possession certificate was issued, they follow all the procedure, my lord. Then this private respondent came into the scene and lodged a complaint, who is even not.
We'll have it on a hearing date.
Yes.
Today may not be possible.
Okay.
Give me a date.
My lord.
Both of you. Yes, Mr. Suman.
Well, I am further responding.
Oh, you have nothing to do, right? When? Mr. Tama?
Many times very well. Tomorrow day after tomorrow.
20? 27. No, small matter. A little bit ahead, whenever you can accommodate.
July, June.
Your LPC has been cancelled.
Cancelled.
As agreed to by the learned counsel for the parties, registered to list this matter again on so and so for hearing. Date to de dega le lena. 4/6.
Okay.
It's a Tuesday. Let it be 5. 6.
I'll be out of state.
4 or 3.
4.
4. Okay. Okay, 4.
Much more.
Yes, Mr. Singh.
My lord, this is an appeal against conviction, my lord. In this case, I have been convicted to undergo RI for 10 years under Section 4 of the POCSO Act.
This is that 2 friends and that girl.
No, man.
No.